Groovy, man. Thank you much. Thank you much.
The committee will reconvene. Excuse me. Today's unclassified hearing follows a classified panel in which members of the Judiciary Committee heard testimony from the Federal Bureau of Investigation, National Security Agency, Department of Justice, and the Office of the Director of National Intelligence regarding the operations and constitutionality of Section 702 of the Foreign Intelligence Surveillance Act, or FISA. In February 2016, the Judiciary Committee held a classified hearing that began our consideration of the reauthorization of the FISA Amendments Act, which was first signed into law in 2008 and reauthorized in 2012. Our hearing last year served as a good background and foundational update on the status of national security operations under the law. Much has happened since the law was last reauthorized, however, including the unauthorized disclosures of classified information by Edward Snowden in 2013 that spawned significant public debate on U.S. government surveillance. We also have many new members who have not yet had an opportunity to directly question experts regarding the statute's successes or areas where reform may be needed. Finally, we have very recent jurisprudence upholding the statute's constitutionality. Like congressional oversight, judicial oversight of this program is an integral safeguard, so exploring various courts' legal analysis concerning 702 will be beneficial for our own oversight as well. Congress enacted FISA in 1978 to establish statutory guidelines authorizing the use of electronic surveillance in the United States for foreign intelligence purposes. Following enactment, global communications infrastructure shifted from satellite to fiber optic wire, altering the manner in which domestic and foreign communications are transmitted. This technological shift had the adverse and unintended effect of requiring the government to obtain an individualized FISA court order to monitor foreign communications by non-U.S. persons. The government had to obtain probable cause to investigate a foreign national located overseas, an untenable proposition that served to extend rights under the U.S. Constitution extraterritorially and limit lawful U.S. intelligence activities. In 2008, the FISA Amendments Act corrected this anomaly by establishing procedures for the collection of foreign intelligence on targets located outside U.S. borders. At its core, Section 702 of the Act permits the Attorney General and the Director of National Intelligence to jointly authorize the targeting of non-U.S. persons reasonably believed to be located outside the United States. As an important safeguard, the Act prohibits the use of Section 702 to intentionally target a person inside the United States and forbids so-called reverse targeting, using Section 702 to target a person outside this country if the true purpose of the acquisition is to target someone inside the United States. Furthermore, the government may not acquire a communication to which all parties are known to be inside the U.S., and all Section 702 acquisitions must be conducted in a manner consistent with the Fourth Amendment to the Constitution of the United States. Section 702 also prohibits the intentional targeting of a U.S. person outside the United States. Instead, Sections 703 and 704 of the Act preserve Fourth Amendment protections for U.S. citizens by requiring the government to obtain an individualized order from the FISA court, known as the FISC, to acquire U.S. persons' communications while they are outside the United States. America's intelligence community has deemed Section 702 its most important tool in battling terrorism. However, it has also been criticized by some as an overly broad program that collects communications of U.S. citizens without sufficient legal process. Today's classified and public panels afford members an opportunity to examine Section 702 collection in greater detail and probe the aspects of this important collection with which they may be concerned. The Judiciary Committee has primary jurisdiction over FISA. During committee consideration of the USA Freedom Act, I made a commitment to members that the committee would separately undertake fulsome oversight of the FISA Amendments Act, which is slated to expire on December 31st of this year. This hearing is the first step of this Congress toward a detailed, thorough, and careful examination. I thank all of our witnesses for testifying today. These individuals represent multiple viewpoints to ensure that this is a well-rounded debate that gives voice to diverse stakeholders. We must ensure that our protection doesn't come at the expense of cherished liberty. Every single one of us who has promised to uphold the Constitution has a duty to ensure that surveillance authorities are crafted and employed in a manner consistent with our oath and the expectation of all Americans. Strong and effective national security tools like Section 702 and civil liberties can and must coexist. With that, I'm pleased to welcome and recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. And I thank the second panel of witnesses for being here and joining us today. As has been noted, last Congress we enjoyed a relative amount of success working together in a bipartisan fashion to pass the USA Freedom Act. We demonstrated that privacy and security are not necessarily mutually exclusive values. Our bill did not contain every reform I had hoped to see, but it shows that our committee is capable of crafting authorities that serve the government's needs and respects our commitment to civil liberties. There are a few important lessons from that project worth repeating as we undertake this next round of surveillance reform. We're all in this together. The members of the committee include some of the most progressive Democrats and conservative Republicans in the Congress, but no matter, we have shown that both in this committee and on the House floor, we can build consensus around our common values. Among those values are a dedication to privacy, to transparency in government, and to the protection from unreasonable search guaranteed to the people by the Fourth Amendment. I've enjoyed working with our coalition in the past, and I look forward to doing so here as we seek the basic reform that I think is needed for Section 702. We cannot do this work well without the assistance of the intelligence community. On April 22, 2016, several members of this committee wrote to Director Clapper to request that he prepare a public estimate of the impact of Section 702 on United States citizens. We were not the first to make this request. As early as 2011, Senators Wyden and Senator Udall had asked for similar information. By the time we wrote our letter, more than 30 civil liberties organizations had petitioned the director for the same. I was encouraged by the government's initial response. ODNI and NSA took the extraordinary step of holding an unclassified briefing for our personal staffs. Over the next few months, they held additional discussion with committee counsel. On December 16, our group of members again wrote to Director Clapper to memorialize our understanding of the project. The government has pledged to provide us with an estimate of the impact of 702 on United States citizens. Both the estimate and the methodology used to reach it will be made public. The government also promised to provide this information in time to inform the debate on reauthorization when it begins. And without objection, I ask that both letters of mine be placed in the record.
Without objection, they will be made a part of the record.
Thank you. Unfortunately, here we are at the beginning of our debate, And the intelligence community has not so much as responded to our December letter, let alone completed the project. I had hoped for better. The members of this committee and the public at large require that estimate if we're to engage in a meaningful debate. We'll not simply take the government's word on the size of the so-called incidental collection. And this problem illustrates my final observation. We should all do a better job of distinguishing between technical legal arguments and the values at play in this discussion. They're both different and they're both important. Here are the facts. The law prohibits the government from using Section 702 to target any United States citizen. Nevertheless, the government can and does collect massive amounts of information about our citizens under this authority. The members here are well aware that this practice has been read into the statute by the government and ratified many times over by the Foreign Intelligence Surveillance Court. We know it is not unlawful in that respect. We also understand that the men and women of the intelligence community have a duty to keep us safe within the four corners of the law, and that they take this obligation seriously. Our criticism comes from someplace else. The idea of using this authority to collect large amounts of information about United States citizens without a warrant or individualized suspicion, and then applying that information to purposes having nothing to do with counterintelligence or counterterrorism is, in a word, wrong. It does not comport with our values or those that underscore the Fourth Amendment to the Constitution. And at the end of the day, as the sunset of this authority draws near, the manner in which one collects, retains, and disseminates this information is only lawful if Congress says it is. And so I am eager to hear those witnesses that are present with us today and engage in this inquiry. I thank the chairman and yield back any time remaining.
Chair thanks the gentleman. We would welcome our distinguished witnesses today, and if you would all please rise, I'll begin by swearing you in. Do you and each of you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that all the witnesses have responded in the affirmative. Mr. Jeff Kosseff is the assistant professor at the United States Naval Academy's Cyber Science Department. Previously, Professor Kosseff practiced cybersecurity and privacy law at Covington and Burling and clerked for Judge Milan D. Smith, Jr. of the United States Court of Appeals for the Ninth Circuit and for Judge Leonie M. Brinkema of the United States District Court for the Eastern District of Virginia. Before becoming a lawyer, he was a journalist for the Oregonian and was a finalist for the Pulitzer Prize for National Reporting and recipient of the George Polk Award. He is a graduate of Georgetown University Law Center and the University of Michigan. April Doss is currently a partner at the law firm Saul Ewing, where she chairs the firm's Cybersecurity and Privacy Practice Group. From 2003 to 2016, Ms. Doss worked at the National Security Agency, where she served in a variety of roles. She worked on information sharing policy, managed counterterrorism programs, led innovative compliance processes in new technology development, served as an intelligence oversight program manager, lived overseas as a foreign liaison officer, and provided legal advice on NSA's intelligence activities. From 2014 to 2016, she was the Associate General Counsel for Intelligence Law, responsible for providing legal advice on NSA's global intelligence operations, technology capabilities, privacy and civil liberties, and oversight and compliance programs. Ms. Doss is a graduate of Goucher College, Yale University, and UC Berkeley Law. Elizabeth Goitein co-directs the Brennan Center for Justice's Liberty and National Security Program at the New York University School of Law. Before joining the Brennan Center, she served as counsel to U.S. Senator Russell Feingold. As counsel to Senator Feingold, Ms. Goitein handled a variety of liberty and national security matters with a particular focus on government secrecy and privacy rights. Previously, she was a trial attorney in the Federal Programs Branch of the Civil Division of the Department of Justice. Ms. Goitein is a graduate of Yale University, the Juilliard School, and Yale Law School. Adam Klein. Mr. Klein is a senior fellow at the Center for a New American Security, a bipartisan national security research organization in Washington. His research centers on the intersection of national security policy and law, including government surveillance in the digital age, counterterrorism, and rules governing the use of military force. Previously, Adam served as a law clerk to Justice Antonin Scalia of the United States Supreme Court and Judge Brett Kavanaugh of the U.S. Court of Appeals for the D.C. Circuit, and was a senior associate at Wilmer Hale. He has also worked on national security policy at the RAND Corporation and the 9/11 Public Discourse Project. He is a graduate of Northwestern University and Columbia Law School. Welcome to all of you. We will proceed under the 5-minute rule. There is a timer, I think, right in front of you there. When you get down to 1 minute, I think it will warn you that you have 1 minute left. Please summarize at that point. Your entire statement, written statement, will be made part of the record. We'll start with you, Mr. Kosseff. Am I pronouncing your name correctly?
Yes.
Good, thank you.
Mr. Chairman, Mr. Ranking Member, and members of the committee, thank you for the opportunity to testify about 702. My name is Jeff Kosseff, and I'm an assistant professor at the U.S. Naval Academy, where I teach cybersecurity law. The views that I express today are only my own and do not necessarily represent the DoD or its components. Some of my testimony today is drawn from a Hoover Institution paper that I published last year with my colleague, Chris Inglis, who served as the Deputy Director of the NSA. I initially was quite hesitant to work on a paper about 702 with the NSA's former Deputy Director. As a lawyer, I have represented media organizations, sometimes adverse to government agencies. Before becoming a lawyer, I was a journalist. I suspect the committee would agree with me that journalists may be an especially skeptical bunch, and I was highly skeptical about the constitutionality of a government surveillance program that I understood primarily through reading the media accounts of the Snowden leaks. Nonetheless, I evaluated the entirety of the program based not only on media reports, but also on the public primary source record. What I found was an effective program that is subject to rigorous oversight by the 3 branches of government and, on balance, complies with the Fourth Amendment. That is not to say that I easily arrived at my conclusion, nor do I deny that there are some aspects of the program that raise very, very difficult Fourth Amendment questions. To start with the Fourth Amendment analysis, we have to look at whether there was a warrant or an exception to the warrant requirement. I agree with the FISA Court of Review that foreign intelligence can be considered a special need that is separate from law enforcement and is exempt from the warrant requirement. The FISA Court has held that this exception covers 702, and I agree with this conclusion for the reasons stated in my written testimony. Even if warrants are not required, the Fourth Amendment demands an assessment of the reasonableness of the search by balancing the intrusion on individual privacy with the promotion of legitimate government interests. The public record strongly supports the conclusion that 702 is an effective national security program. For example, the Privacy and Civil Liberties Oversight Board noted that more than 25% of the NSA's reports about international terrorism rely at least in part on 702 information. 702 is simply a more nimble alternative to Title I of FISA, which was designed to protect subjects who are U.S. persons. On the other side of the balancing test, we must assess the invasion of the individual's privacy interests. The statute explicitly prohibits the government from using 702 to intentionally target persons known to be in the U.S. or U.S. persons, and it explicitly prohibits reverse targeting. 702 programs are subject to a number of additional procedural safeguards, including oversight from all three branches of government, certification requirements, and minimization and targeting procedures. That said, the FBI's querying of 702 data for evidence of a crime, I believe, raises the most difficult Fourth Amendment issues. In a recent FISA court proceeding, amicus argued that each FBI query of 702 information is a separate action subject to the Fourth Amendment reasonableness test. Judge Hogan correctly rejected that formulation and instead evaluated the 702 program as a whole. Judge Hogan set forth a compelling case as to why national security interests outweigh the intrusion on privacy. Importantly, the FBI and other agencies can only query data that has been obtained through the certification, targeting, and tasking procedures. Only a subset of the 702 information is available to the FBI for queries, and the FBI does not receive unminimized information obtained through the NSA's upstream process. On balance, the FBI's ability to query 702 data as described in the public record does not render 702 unconstitutional. During the reauthorization process, Congress may well conclude that there are legitimate policy reasons to limit the FBI's ability to conduct such queries. However, my testimony today is limited to the application of the Fourth Amendment to 702. The intelligence community continues to increase the amount of information available to the public about 702, and this is absolutely crucial. I commend these transparency efforts, recognizing the tremendous difficulty caused by the inherently classified nature of foreign intelligence programs. Further, and importantly, the work of the Privacy and Civil Liberties Oversight Board has been absolutely essential in informing the public debate about 702. The Fourth Amendment, like other important constitutional rights, is highly fact-dependent, requiring close analysis of not only how the program is structured by statute, but how it actually is being implemented. And that analysis must be ongoing, and that's why transparency is so vital to our constitutional analysis. Thank you, and I look forward to your questions.
Thank you. Ms. Doss, welcome.
Mr. Chairman, Mr. Ranking Member, members of the committee, thank you for the opportunity to testify about Section 702 of the FISA Amendments Act. My name is April Doss. I am a partner at the law firm Saul Ewing. Prior to that, I spent 13 years at the National Security Agency. Although my perspective is informed by the years I spent in the intelligence community, the views expressed here are solely my own and do not represent the NSA or any other agency or organization. Like many other Americans, I recall exactly where I was on September 11, 2001. And not long after that, I began working at the NSA, where over the years I managed counterterrorism programs, conducted intelligence oversight activities, and spent a number of years in the Office of General Counsel, where, among other things, I served as the Associate General Counsel for Intelligence Law, responsible for providing legal advice on all of NSA's overseas intelligence operations, technology development used for those operations, and privacy, civil liberties, and oversight and compliance programs. Having worked at NSA both before and after the passage of the FISA Amendments Act, and having worked with that authority from a number of perspectives, I can attest to the following observations from my personal experience. In 2008, when the law was passed, the authority was critically needed because of the gaps created by the ways in which technology and intelligence targets had changed in the years since the original FISA was passed, the very points that Mr. Chairman referred to in his opening statement. The 702 authority strikes an appropriate balance between the government's need for foreign intelligence information and the privacy impacts on individuals, the very same critical points that Mr. Ranking Member pointed to in his opening statement. The statutory framework incorporates robust oversight requirements and privacy protections. Those protections have been implemented across all three branches of government in meaningful and substantive ways. And the 702 authority has consistently, since its passage in 2008, provided critical intelligence information to the U.S. and to its allies, including intelligence critical to supporting warfighters in the field that would not have been obtainable in other ways. FISA appropriately balances individual privacy and national security. One point to start with, despite some public misconceptions to the contrary, FAA 702 is a targeted intelligence authority. It's not bulk collection. The collection can only be initiated when an analyst is able to articulate and document a specific set of facts to meet the statutory and procedural requirements for demonstrating that a specific facility is associated with a specific user who's a non-U.S. person reasonably believed to be located outside the U.S. and likely to possess or communicate foreign intelligence information. Although a large number of selectors have been targeted under 702, they've only been tasked for collection because on an individualized, particularized basis, each of them meets all of those criteria noted in the law. And because of the tailored and documented and carefully overseen manner in which the front-end collection is carried out, it's neither unlawful nor inappropriate, in my view, to query that collection for U.S. person information when there's a legitimate basis to do so. And those legitimate bases may include both intelligence purposes and law enforcement purposes, as articulated by Judge Hogan in his November 2015 court opinion. The government has a compelling national security need to be able to carry out U.S. person searches of that collected information in appropriate cases. As an intelligence community lawyer for many years, I know firsthand just how often urgent, time-sensitive operational needs arise. And I can tell you it's my view that if it were necessary for intelligence analysts who work 24 hours a day, 7 days a week, to receive prior approval from somewhere outside of the NSA or the CIA or the FBI, for instance, from the FISC, to conduct a query, that could have a significant detrimental impact on intelligence activities. With respect to the question of estimating the amount of U.S. person information that's incidentally acquired in 702 collection, this is a critically important question that goes to the heart of this balancing between national security and privacy. However, I do believe that it raises significant privacy implications in how that might be done. The challenge, of course, being how to have the reference information that an intelligence analyst would need to know who the user is of an unknown identifier or where that user is in the world. In my view, the collection and maintenance of that reference information would itself pose significant impacts to privacy. During 13 years at the NSA, I had the opportunity to witness firsthand the critical importance of this authority in supporting U.S. troops in detecting terrorists' plans and intentions and other critical intelligence needs, and in protecting the U.S. and its allies. Many of those instances remain classified, but the PCLOPS report, I think, points to the importance of that collection and its sheer volume. Thank you, and I look forward to the committee's questions.
Thank you, Ms. Doss. Regrettably, we're going to have to recess for votes that are on the floor with about 5 minutes remaining in the call, and there are several votes, so it may be a little bit of time. So if you haven't had anything to eat or want to take a break, please do so. We will reconvene as soon as the votes conclude. Yeah, I will say 45 minutes. We'll come back just as soon as we possibly can and work through this. And while we're over there, we'll encourage our colleagues to come join us. Thank you. Committee will stand in recess.
I thought everybody was fidgety because I was taking so long. I kept looking at the clock and I was like, I think I'm okay.
So hi, Kate Wilkins with the Wall Street Journal. I just wanted to introduce myself.
Hi, Jeff Kosseff.
Hey, I wanted to be here for the whole panel, but I'm already so late.
Yeah.
I'm sure
We
you guys
all
are in the same boat,
understand.
right?
We all understand.
Yeah, I just wanted to exchange contact info.
Absolutely. I'll give you my card. It's nice to meet you, Kate.
Do you work with Janet Adamy?
Yes, she sits right near me.
She was my editor on my school newspaper in a year that I do not even want to
Members? Okay. Judiciary Committee will come to order, and I believe that Ms. Goitein, you're up next.
Mr. Chairman, members of the committee, thank you for this opportunity to testify on behalf of the Brennan Center for Justice. Congress's goal when it passed the FISA Amendments Act in 2008 was to give our government more powerful tools to use against foreign threats. Consistent with that goal, Section 2 of the Act has been used to monitor suspected terrorists overseas, to trace their networks, and to disrupt their plots. All of us in this room, I imagine, support that goal and those activities. We're here today because of the other things that Section 702 has been interpreted to allow. The government is not simply monitoring foreign terrorists and foreign suspects. Instead, it's scanning the content of almost all of the international communications that flow into and out of the United States, and is acquiring hundreds of millions of communications each year. We know from how the data is collected that it includes a massive amount of Americans' communications. But despite repeated requests by members of this committee, the government still has not managed to provide an estimate of how many Americans' communications are swept up. We also know that despite being required to minimize the retention and use of Americans' data, the government keeps that data for years and routinely searches it for information to use against Americans in ordinary criminal proceedings. According to the Privacy and Civil Liberties Oversight Board, the FBI searches the data when performing assessments, which are investigations that lack a factual predicate. That means the FBI is reading Americans' emails and listening to their phone calls without a factual basis to suspect wrongdoing, let alone a warrant. I don't believe this is what Congress had in mind when it passed Section 702. In writing the law, however, Congress did give significant discretion to the executive branch and the FISA court, trusting them to implement the statute in a manner consistent with its objective. So for instance, Congress allowed the targeting of any foreigner overseas, trusting the government to focus its efforts on those who pose a threat to us. Congress also left it to the executive branch and the FISA court to come up with specific minimization rules. I don't mean to imply that this trust was misplaced. In fact, we've seen essentially no evidence of intentional misuse. But what we have seen is mission creep, so that a law designed to protect against foreign threats to the United States has become a major source of warrantless access to Americans' data and a tool for ordinary domestic law enforcement. This outcome is contrary not only to the original intent of FISA, but to Americans' expectations and their trust that Congress will protect their privacy and their freedoms. As it now stands, law-abiding citizens of this country and others are vulnerable. Their personal information sits in massive databases where it's subject to being hacked by the Russian or Chinese government, cyber criminals, or I suppose a 400-pound hacker sitting on his bed. American technology companies are facing the real threat that they'll be unable to do business with foreign companies and customers because of our government's collection practices. And yes, there is the potential for abuse. Remember that Congress passed FISA in 1978 because multiple presidents had abused surveillance authorities to target political opponents, personal enemies, and disfavored ideologies and minority groups. In today's tumultuous political environment, we would be naive to think that could never happen again. We can't rely on the courts to supply the missing protections. The few judges that have reviewed Section 702 have upheld it. They're not delusional, they're not so-called judges, but they are applying Fourth Amendment precedent and doctrines that are hopelessly unsuited to the digital globalized era. This is a classic case of the law failing to keep up with technology. When that's happened in the past, Congress has acted to fill the gap. Just a few weeks ago, as you know, the House, by unanimous voice vote, passed the Email Privacy Act. Americans are counting on you to do the exact same thing here, to protect the privacy of their emails and other communications. Thank you, and I look forward to taking your questions.
Thank you, Mr. Klein.
Thank you, Mr. Chairman and members of the committee. Thank you for inviting me to testify today. My name is Adam Klein. I'm a senior fellow at the Center for a New American Security, which is a bipartisan research organization that develops strong, pragmatic national security and defense policies. In a recent report, two colleagues and I offered more than 60 recommendations for the future of surveillance policy, including Section 702. Our research was informed by private consultations with dozens of current and former government officials, technology experts, legal scholars, and privacy advocates. We concluded that Section 702 is a valuable intelligence tool and should be reauthorized with current authorities intact. In particular, we were moved by the measured but largely positive judgment of the Bipartisan Privacy and Civil Liberties Oversight Board, which concluded that the program has been valuable and effective, found no evidence of intentional abuse, and reported that over a quarter of the NSA's reports on international terrorism were based in whole or in part on Section 702. Our report also noted, however, that important intelligence programs, including Section 702, will not be politically sustainable unless the public has confidence that they're being used in a lawful and appropriate way and that they are subject to strong oversight. So the challenge for us was to enhance public trust without diminishing Section 702's effectiveness as an intelligence tool. My written testimony lists more than a dozen concrete, actionable ways Congress can do this as part of this process. I'll just highlight a few here. First, and I think this is the most urgent issue facing the committee during the reauthorization process, Congress needs to revive the Privacy and Civil Liberties Oversight Board. The board has provided excellent oversight of Section 702. Its positive judgment about the program is one of the best arguments for why the program should be reauthorized. Unfortunately, the board is now paralyzed because it has no chairman and has too few members to take official action. My written testimony contains several proposals for reviving and enhancing the board. I'll just note one here. The Foreign Intelligence Surveillance Court, before it issues the annual order that allows Section 702 to operate, should be required to confirm that the President has made nominations to any vacancies on the board. This will give presidents a real incentive to nominate members to the board, something that has been a problem since the board was created. Another area where there's room for pragmatic reform is queries of Section 702 information using U.S. person identifiers, especially FBI queries and criminal investigations that are not related to national security. This practice does raise real civil liberties concerns, but at the same time, there are reasons not to prohibit these queries altogether, or at least to be very cautious before doing so. The 9/11 Commission explained that the inability to connect the dots between domestic law enforcement and foreign intelligence was a key reason why the government did not disrupt the 9/11 attacks. If there's a connection between the subject of an FBI investigation in the United States and a foreign terrorist or a spy or a proliferator who's been targeted under 702, we want the FBI to know that. Now, that said, there are ways to address privacy concerns short of banning these queries altogether. The most important is transparency. So the government should provide more information about the number of such queries, about how often they return Section 702 information, and about how the Justice Department uses that information downstream in the criminal justice system. Another possibility worth exploring is whether the FBI could continue running all the queries it runs today, but in some subset of them receiving only the metadata of the responsive communications initially instead of the underlying content. That could be enough to reveal any connections to problematic foreign actors. One final recommendation I'd like to highlight. The USA Freedom Act created a pool of cleared advocates to present public interest arguments before the FISA court. Now, whether to appoint one of those advocates is currently in the court's discretion. We believe that Congress should make it mandatory in at least one case a year, the court's annual review of Section 702. That's a very easy way to strengthen judicial oversight of 702 with absolutely no cost for national security. Thank you, and I look forward to your questions.
Thank you. We're now going to proceed into the 5-minute questioning. The three of us, and if anyone else shows up, we'll have an opportunity to question you. I'm going to recognize myself for the first 5 minutes of questioning. And Mr. Kosseff, am I pronouncing that right? Kosseff? And then I would like, if you care to, each member to answer my first question, which would be very simple. Is there anyone here that believes that we should not reauthorize this legislation?
I believe you should reauthorize.
We
those.
should reauthorize.
Yeah, yes.
I'm in favor of a clean reauthorization.
That's good.
Sorry, I would be in favor of reauthorization if there were significant reform.
Okay. Mr. Klein?
Yes, I support it as well, reauthorization.
Ms. Goitein, you stated that, although not intentional at this point, did you say thousands or millions of names were gathered up, information was gathered up? Did I paraphrase that correctly? Did you say that you thought that there were thousands or maybe even millions of names or information gathered up unintentionally?
Not unintentionally. It's part of the incidental. The terminology gets mixed
yes.
up, but incidentally is the terminology that's used by the government. But it is part of the design of the program, is to acquire communications of foreign targets with Americans as well as with others. And so as an inevitable result of that, millions of Americans' communications, which is the best estimate that anyone can have until the government provides a more accurate estimate, are being collected.
Can you give me another example or an example of how you come to that conclusion?
Sure. Well, one example is that there are 250 million internet communications that are acquired each year under Section 702. At least that was the case in 2011. If you, and this is collecting all of the communications of the targets, if you assume that...
There's the big word, okay, assume. So are you basing this on
Well, that's all we
a
can do.
mathematical calculation?
Well, we don't, unfortunately, after a year of asking for it, the intelligence community still has not given the committee the numbers we would need to do an actual calculation. So if you conservatively assume that even 1 out of 100 of every foreign target's communications was with an American, that would still be millions of Americans' communications.
You're dealing with a career prosecutor here. I don't assume anything.
I would like not to assume. I would love to have the facts.
Mr. Klein, what say you about that?
I actually agree with Ms. Goitein's description of incidental collection. I mean, this is something that's been documented by the Privacy and Civil Liberties Oversight Board, that this is a realistic prospect that this happens in substantial volume. And there have been statistical transparency reports by the intelligence community documenting, among other things, U.S. person identities that are part of disseminated intelligence reports. This is on page 6 of the 2016 transparency report. So this is a real thing, but at the same time, there are measures in place to ensure that the U.S. person information collected through the program is minimized, is used only in specified ways subject to the supervision of the FISA court. So there are safeguards in place, but I do think that greater transparency would help boost public trust in that.
And Mr. Kosseff and Ms. Dawes, do you have
I fully support transparency in terms of the numbers of incidental collections of U.S. persons' information. However, I also recognize there very well may be some logistical difficulties as well as potential civil liberties concerns in terms of how you calculate and how you obtain that information. I'm not an expert on that issue. I just know that's what's been stated in the public record. So I think that always will have to be balanced with the need for transparency. But absolutely, if there was a way to get those numbers, that would be excellent.
Ms. Dawes?
From a practical perspective, I believe that it would be far more intrusive on privacy and really not feasible to come up with those numbers in a meaningful way, and I'll explain briefly why. I touched on it in my written testimony as well. The challenge is that when the intelligence community is targeting a foreign intelligence target, there's no way a priori to know who the target will be in communication with. Intelligence analysts and their tradecraft typically look for communications of intelligence value, not for irrelevant ones. And when they see communications of value, they will inevitably find unknown identifiers, which might be phone numbers or email addresses. The challenge is that there is nothing inherent in the unknown identifiers that can definitively point not only to where the other communicant might be, but to what their nationality and citizenship and identity are. So in order to make that determination, My view is the intelligence community would be required to have a significant amount of reference information about U.S. people who are of no intelligence interest in order to identify the U.S. person communications.
Could I briefly respond to that?
Briefly, my time's expired, but go ahead.
Okay. For two of the programs under Section 702, it should be very straightforward to collect the information. For the phone collection, a country code will suffice as an estimate. There's no need to do research or have reference information. It's not 100% accurate, but it's accurate enough for the estimate that we seek. For the purpose of internet collection, for upstream collection, the IP address serves as a proxy for country. It is a reliable enough proxy that the NSA relies on it to try to filter out wholly domestic communications. If it's reliable enough for that purpose, it's reliable enough for the estimate that we have sought. The difficult program is PRISM. That's where it's a bit harder. And I would just say that we are aware of all of the problems in terms of trying to figure out the nationality of US persons. There are privacy implications, but the privacy community has unanimously come down on the side of saying that this would be a net gain for privacy if there were a limited one-time sampling under conditions that we have laid forward in a letter. Okay. So while I appreciate Ms. Doss's concerns, I think the privacy community feels differently.
All right, I have it. My time's expired. Congressman Liu from California, you're up.
Thank you, Mr. Chair. Having served on active duty in the military, I believe when it comes to terrorists, we need to hunt them down and kill them. And I don't think anyone on this committee has any problem with Section 702 and how it goes after foreign bad dudes in foreign nations. I think some, and perhaps many of us, have a concern when we're talking about American citizens and how they incidentally get caught up in this surveillance. And under Section 702, if you're an American citizen and you're caught up in this surveillance, that information can be passed to the FBI to then do a criminal proceeding and do a criminal case against you. To me, that's just a flat-out violation of the Fourth Amendment. And so for those of you who want a clean authorization, why do we even need that? Why don't we just require a warrant, as the Fourth Amendment does? How does going after American citizens for a criminal case that's unrelated to a target or foreign inquiry, how does that help our national security? And I guess that's my first question to those who think there should be no reforms to this section.
Well, to touch on that, one of the main justifications for having that ability has been that let's say that the FBI were searching for their unified database for an American U.S. identifier, they could then come up with a hit on 702, and that would tell them additional information about a potential foreign intelligence threat. So that's one justification. And the other justification is going back to the wall between FBI and intelligence data that existed pre-September 11th. So those are two justifications for it. I also fully see your point on there being concerns about the FBI having that access. When it comes to a Fourth Amendment issue, that's a little different. I'm not aware of any cases where a subsequent query of data that had been lawfully collected constitutes its own separate Fourth Amendment search. So there very well may be some very strong policy reasons to change the FBI's ability to query that data, but I see that more as a privacy and policy concern than a Fourth Amendment issue just under the doctrinal Fourth Amendment law.
Thank you. Yes, go ahead.
I would disagree on the Fourth Amendment analysis. The notion that that restrictions on searches of lawfully acquired information or lawfully accessed property is somehow not a part of the Fourth Amendment is simply not the case. It's actually the constitutional norm. The terms of access to information or property are generally set forth in the warrant, and they usually do require limits on searches. So that if I obtain a warrant to search a computer, for example, in a case where I have shown probable cause of a copyright infringement, I can take that computer, I can copy the hard drive, I lawfully have that information, but I am only permitted to search for the evidence of copyright infringement. After I find that, I can't go pulling up the IRS returns to look for evidence of tax fraud. So usually that's built into the warrant as a restriction on searching. It is part of the terms of access. The terms of access of 702, of getting this information without a warrant, is that the government has no intent to target any American, any particular known American. They have to certify our interest is only in the foreigner, not in any particular known Americans. And I would argue that that serves as a constitutional barrier to a warrantless search after collection.
Thank you. And I think you had touched on this earlier. I just want to get it very clear from you. You would believe that responding to a request for information that this committee has sent out to intelligence agencies about sort of the statistics, you think that on balance, it's better to get that information versus
Yes.
any privacy concerns?
I believe so, and 30 civil liberties organizations have signed a letter saying that, including the major national privacy organizations in this country.
And then let me conclude by just saying, you know, all of us here and those intelligence agencies took an oath not to an administration or to a political party or to an agency. It was an oath to the Constitution. And what that means is even if a program may be effective or not effective or incredibly brilliant, if it violates the Constitution, we just can't execute it unless we change the Constitution. And I just hope people understand that that's what it means when we all take an oath to the Constitution, that that is the primary document to which we owe our allegiance. And with that, I yield back.
Chair recognizes the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman, and thank you all for being here today. I think it is the responsibility of this committee and every member of Congress to ensure that the privacy and the Fourth Amendment rights of every U.S. citizen are protected and remain of paramount importance to this government. Professor Kosseff, am I pronouncing your name correctly? In Ms. Goitein's testimony, she highlighted that as of 2011, more than 250 million internet transactions a year are being collected by the government. Is it possible to subject the collection of 250 million transactions a year to rigorous oversight?
I would, based on the procedures that the NSA has developed and my understanding of the procedures through the Privacy and Civil Liberties Oversight Board's report of it, I am very impressed by the multiple levels of analysis that have to go through the targeting decisions, the certifications, and the minimization procedures, and the oversight for each throughout all three branches of government. So I do think that it is possible. I do think the volume obviously makes it very difficult, but I also don't think that's a reason not to do it. If there are ways to strengthen the oversight, then that would definitely be something worth looking at. But at least from a Fourth Amendment perspective, I think that is possible.
Ms. Goitein, do you think it is possible to subject this to rigorous oversight?
I think there is some indication, even in Ms. Doss's testimony, that it may be a little too much of a challenge, that while there has been no inadvertent lack of compliance with the rules, there have been repeated instances of noncompliance with FISA court orders and with court-ordered procedures. And I'm not talking about trivial technical violations. I'm talking about violations that were systemic, sometimes quite prolonged, and that resulted in significant over-collection and unauthorized searches. And again, this was not through bad faith. There's essentially two explanations, and one is that the oversight isn't enough or isn't working, and the second explanation is that the system is so large and so technically and legally complex that compliance is effectively impossible. And if it's—
So let me just stop you there because I only have 5 minutes. So for me, a particular concern, and this is not a political question, it just had a chilling effect on me because I've been a critic of, or at least a proponent of strong reforms in this system now for several years. But I was concerned when I saw that Michael Flynn's information was made public. So we have heard that there's supposed to be all these guidelines that are supposed to protect the identity of people. And whatever your political persuasion is, for me, it had a chilling effect, that I thought my political opponents could use my personal information that they maybe gathered in some private communication against me in the future. So that should be quite terrifying to anybody, whether you're a Republican or a Democrat. Mr. Kosseff, you mentioned that the numerous statutory limitations have been put in place to limit the invasion of privacy. It seems that even with these limitations to protect the privacy of the average American, somehow leaks are happening. In Mr. Flynn's case, these leaks not only invaded his privacy, but also crippled and ultimately prevented the commander-in-chief from having his key national security personnel from doing his job, which you may have a political opinion about or not. How do we trust these intelligence agencies to ensure that our national security, when they're divulging highly sensitive information to settle scores, or can we prevent them from using this personal information to settle scores?
Well, I can't speak to those specific.
So let's just use that as an example, because that's an example that now the American people can relate to. It's what some of us have been warning about for years. And all of a sudden it happened, and it's a real life example where somebody's sensitive information was used for a political purpose, whether you agree with that political purpose or not.
Sure. So putting that aside, I think in terms of the oversight, I think trust is by far the most important characteristic of a program like 702 or really any other intelligence program. And
Well, but the Fourth Amendment was put in place because we don't trust the government.
Yes,
Ms. Goitein, can you explain, without taking a political position on this, shouldn't we be alarmed by this?
I think what you're touching on relates to essentially the history of FISA and why it was put in place, which is that surveillance was, and I'm not taking a position on the particular surveillance in this case. I'm taking a position more on your response to it and your sense that you're chilled to some degree by the possibility that your communications could be acquired. And they could be. Under Section 702, they could be. And I think that is something that really ought to be of concern because the statute is not narrow enough. It doesn't limit the government to conducting surveillance of foreign threats to the U.S., and that opens the door to potential abuses. It opens the door to possible political surveillance. That's why FISA was enacted in the first place in 1978, because those things were happening. And Section 702, while it responded to a real threat and it intended to address that threat in an effective way, it also eliminated some of the protections that might prevent the chilling that you're experiencing.
Thank you.
Gentleman's time has expired. Chair now recognizes the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. Ms. Goitein, we sent a letter a year ago. Your group may have been part of putting this letter together. I signed on to it, asking Mr. Clapper the number of Americans whose communications have incidentally been collected under Section 702 of FISA. Yeah, can you hazard a guess? They wouldn't give us the number. Can you hazard the guess?
I had said earlier millions, which I think is conservative.
You think it's millions?
Yes, potentially tens of millions. I don't know. I really hesitate to speculate. I know that speculation is discouraged. I wish I had better numbers for you.
So the response they give back to me, they give me a short little 3-paragraph response, and they say this: the operative sentence or clause says the number of Americans whose communications have been incidentally collected under 702 is very difficult, if not impossible, number to calculate. That seems like baloney to me. It seems like that would be relatively easy to calculate. We're talking about the greatest intelligence service on the planet. You'd think they would be able to know that, right?
Well, I think if we were asking for an accurate calculation, it actually would be difficult. We're asking for an estimate, and I don't think
an estimate.
Certainly for 2 of the 3 programs under Section 702, it should be quite straightforward.
Okay, let me just, I just want to make sure I know exactly how this works. So there's a bad guy who who's not an American, who's overseas, that we want to surveil him. So we go to the procedure, and this individual is going to communicate with an American. So on the front end, my understanding is the FISA court says the procedures on how you're going to handle communications to and from or about Americans, there's on the front end, the FISA court says, okay, those procedures, when you get in this situation, this is how you're going to conduct yourself. Is that right?
Yes.
Okay. And so now it happens, the bad guy communicates with an American, and we now have the American's phone conversation, the content of those phone conversations, and the content of those email or whatever electronic communications, right?
Yes, presumably.
Okay. And let's, what happens when they look at, first of all, how are those communications stored?
It depends on the agency. Let's say the NSA collects the communications. The
Right.
NSA, through, let's say, the PRISM program, then the NSA can just keep it in its own databases, can also give it to the FBI and to the CIA, the raw data with the Americans' information in it, to those agencies.
When you say raw data, is that the content of the actual email content? And the
Yes.
actual conversation, the actual content of those conversations?
Yes, that's
Okay,
right.
so that content could be on multiple databases,
Correct.
FBI, NSA, various federal agencies, right?
Correct.
Okay, then how is it, then we have the term queried. What's that mean?
A query is when an agent who is authorized to access the system and to run the query usually takes an email address or a phone number or some kind of identification or communicator identification to search through the data for a particular individual's communications so that they can look at it.
Okay, so we have it all there, and then we have, let's say Joe Smith's the American, they have all the information on Joe Smith, and they said, now we want to query that. We want to, and it can be triggered just by the name? It could be triggered by what?
I think it'd be much more likely to be a phone number or an email address. That would be, I think, the way that it's usually done.
Okay.
I should say that the NSA and the CIA and the FBI all have rules that provide some limit on when they can query using a U.S. person identifier.
Is the information that was collected under a 702 about Americans, is it tagged differently in the databases that it's in, or is it just part of the overall database?
It's tagged differently.
Tagged differently. So you could selectively go through and just say, I want information collected only under 702 about Americans?
No, I think it would be more likely actually to work the other way, that whoever's running the query, if they get back information that's tagged to 702, they have to be trained in 702 in order to then access that information. But if they're not trained, they just go and ask someone else who is, and they
Okay.
come look at it.
Okay. If when they have that information about the American, can they use that information to let's say the American's done something wrong. Could that American be prosecuted by information gained under 702?
By the FBI, yes.
And could they be prosecuted only for crimes or potential crimes relative to national security, or is it broader than that?
No, it's broader than that. It includes crimes that have no relationship to foreign intelligence or national security.
And has that happened?
That information is not public.
Yeah, we don't know.
And we would know if the government were more faithfully adhering to the notification requirements of the statute, under which the government is supposed to notify defendants when it uses information derived from Section 702.
But do you think it has happened? Where someone, an American, information gathered under 702 about that American is used to prosecute them, and it's used to prosecute them in some area outside of national security. Do you think that has happened?
I'm really not in a position to say. I don't know.
But can you hazard a guess?
I'm
Do
sorry.
you think it's happened?
Section 702 has certainly been used in criminal prosecutions that have a terrorism component, such as material support for terrorism. As for whether it's been used in a case that has nothing to do with national security, I'll put it this way. The FBI, according to the Privacy and Civil Liberties Oversight Board, routinely searches the data, data that includes Section 702 data, for Americans' information when it's conducting criminal investigations that have nothing to do with national security. So I would imagine that if they found something responsive, yes, they would use it. But that is all I can say, really.
Yeah, which is scary. Okay, I thank the chairman, and I thank the witnesses.
Before I go to Mr. Liu and Ms. Doss, can you give us a little explanation concerning your experience about how tagging takes place when something's tagged, if if it's tagged and a U.S. citizen's name comes up when this tagging takes place overseas.
Thank you. Ms. Goitein's testimony fundamentally misstates the facts in that regard, so thank you for the opportunity to clarify. The central challenge with identifying U.S. person communications in collected 702 data is that by and large, the intelligence community will not have reference information to know who the U.S. persons are. They're targeting foreign persons for foreign intelligence reasons. The foreign intelligence target will communicate with any number of people, but appropriately, the government does not have a comprehensive database of all of the identifiers, the phone numbers and email addresses associated with U.S. people. So what happens is the data gets queried looking specifically for foreign intelligence. When an unknown identifier is revealed, if there appears to be intelligence value in the communication, the analyst will then go do the due diligence research that will help them understand whatever information might be available about the communicant's nationality, location, identity. But there's no reference database that says, here's the US people. There are capacities within some, I can't speak for all of the databases that might hold S702 information everywhere. In the CIA, FBI, and NSA, there are capacities to tag data as US person related when it's recognized, but that requires a recognition of it. There isn't any means, certainly not that I'm familiar with, that allows tagging of it upon arrival. And one of the things that's really critically important that Ms. Goitein sort of slipped past in her previous testimony was that there's two dimensions to this: location in the US and US people anywhere in the world. For the question of whether somebody is located in the US, there are instances in which technical data can be helpful in making that determination, and it's critically important. It's not available for all types of 702 data, but it is for some, and that's critically important. That tells you location. That cannot tell you whether or not somebody might be a US person anywhere else in the world, which of course is one of the key protections of 702.
Mr. Liu.
Thank you, Mr. Chair. So let me follow up on the gentleman from Ohio's question to you, Ms. Goitein, and you can also sort of respond to what Ms. Das said as well. So let's say intelligence agency is targeting a foreign national in a foreign country, and then they find out incidentally that an American citizen is buying marijuana across state lines. Could that information be given to the FBI to then go prosecute that American citizen?
Yes.
How is that constitutional? I don't understand why your Fourth Amendment rights somehow get violated just because of how the information got collected on you through this means. I don't understand that.
I think if the government happens upon information of a crime, that there is an argument that that's analogous to the plain view exception to the warrant requirement. Now, I think that that looks very different in a situation where you have a collection program that enables essentially the mass collection of hundreds of millions of communications a year. I'm much more troubled, so I do think that's troubling. I'm much more troubled by the deliberate searching, which is not analogous to plain view, for Americans' information. And I do need to say that I did not say that Americans' information is somehow tagged as Americans' information. I believe I was asked the question whether Section 702 data is tagged as 702 data, which it's required to be tagged as 702 data in the statute. So I think you misunderstood my testimony.
Apologies if I misunderstood.
Okay.
Thank you. So let me follow up what you said. In terms of the scale of this program, so under Section 702, there's three categories generally in which intelligence agencies can go target. The first two I understand. One is terrorism. Second is nuclear non-proliferation issues and so on. But a third is this massive category known as foreign affairs. So that could apply to academics, students, human rights activists, lawyers. It's this massive group. And do you have any idea of how big that group is? Because foreign affairs is virtually everything, potentially.
Again, we unfortunately have very, very little information about how that works in practice. Certainly it is a fear that under the very broad definition of foreign intelligence information in the statute, that would on its face encompass conversations of human rights activists, conversations of journalists with their sources, NGOs that work on important political issues, and things of that nature. One of the certifications on foreign intelligence topics was leaked, and that was the certification for foreign intelligence related to foreign powers. And the foreign powers about which the NSA is authorized to collect information that relates to those foreign powers includes most of the countries in the world, including allies of ours, including tiny countries that have very little role on the world stage, neutral countries with no history of terrorism. St. Lucia is on that list. So certainly on paper, these authorities are extremely broad, and we are trusting in the self-restraint of the people who are operating these programs to not take advantage of that breadth.
Thank you. And then one last question on the Fourth Amendment. As you know, the Fourth Amendment doesn't just say government can't engage in warrantless searches. It also says government can't engage in warrantless seizures. So why isn't the case that the seizure of an American citizen's email, that is a constitutional violation right there before you even start searching? I mean, why isn't it the case that we even allow incidental collection of Americans? Why not just say, if there's incidental collection of Americans, we mask it, we delete it, unless there's a warrant? Why wouldn't that be the case under the Constitution?
Certainly one thing that I believe is constitutionally necessary. Now, as I said, I think the courts have been applying some very old case law to come to different conclusions, but we need much, much stricter minimization requirements. The minimization requirements that exist right now, which are described as strict, allow the NSA, the CIA, the FBI to hold on to Americans' data literally for years. If the FBI reviews data, sees Americans' data, comes to no conclusion about whether or not that is foreign intelligence or not, the 5-year limitation evaporates, and they can hold on to it for some longer period that is still classified. If the information is believed to contain secret meaning, which I think covers every email I ever sent to my sister, then that also is exempt from the age-off requirement. Let's see, what else? The NSA is supposed to purge U.S. person data on detection if it doesn't contain foreign intelligence or evidence of a crime. The Privacy and Civil Liberties Oversight Board reported that this rarely, if ever, happens. The CIA and the FBI have no such requirement. They just rely on these very porous age-off requirements. And all 3 agencies can search the data using U.S. person identifiers. So if you look at these restrictions, such as they are, yes, there are restrictions on the use and retention of U.S. person data. But is that use and retention minimized? Not by any common sense of that word.
Thank you. I yield back.
Chair now recognizes the gentleman from Texas, Congressman Poe.
Thank the chairman. Thank you all for being here. I'm going to pick up where my colleague just, I think, left off. And I want to keep it real simple for me. Not for you, but for me. The government, under secret courts, gets a secret warrant to seize information from a bad guy. Let's just call him terrorist outlaw. And they grab that information from terrorist outlaw from their secret court with secret information, and the warrant for that document, if you want to call it a warrant, is never publicized to the public. Is that correct, Professor? Oh, I guess when I say professor, everybody looks at each other. I'll ask the witness that was just talking. Is it Goitein? Goitein?
Goitein.
Goitein, I apologize. Is that correct? That document, we call it a warrant. I don't think it's a warrant, but that document is never made public. Is that correct? I mean, that's part of FISA. that it's never made public.
Correct.
Okay, so they seize information about outlaw terrorists, and in that information, they inadvertently come across data, emails, phone conversations about some American. And they call that query. Is that correct?
Not if they just stumble upon it. If they're looking for it, then that would be called a query. It's all,
Okay.
It's very technical. There are different
I know.
ways they can find the information.
But they seize it is the point. They seize the information if they come across it, whether it's on, they're not looking for the information because the American's not the target. If it was a target, oh my goodness, we'd have to get a search warrant. So they're going to say that he's not a target, or the American is not a target. They just come across the information, even inadvertently, and if it's on purpose, they got to get a warrant. So I'm going to say it's inadvertently. Let's just assume my hypothetical. They come across it inadvertently. And they read the information, or they have their computers read the information, and they seize that information, and they keep that information on whether it's one American or a bunch of Americans. Is that correct? I'm just asking.
Yes.
So they got that information.
Seize it all together.
Yeah, it's all together. And they got that information, and I think what you said from the last question was, they, in essence, keep that information forever.
Not forever. There are 5 years is the standard.
But they
default,
find excuses.
But there are a lot of exceptions.
Yeah, a lot of exceptions, yeah. So they got this information, and I don't believe the NSA ever destroys information, ever, on anybody. But once they have that information, and then they determine that that information is that this person, this American, may have violated the law. Then they make that person a target. They've got more information, and then they can file criminal charges on that information. Is that right or not?
Well, I mean, what worries me is, I guess it depends what you meant by making the American a target. If they actually made the American a target, legally speaking, and went and got a warrant or a FISA court order, we'd be in a different world. But that's not what happened.
But that's not what they do. That's not what they do. They get the information, they read the information, it's inadvertent. Oh, this guy may be a troublemaker as well. And they get more information based upon connecting all the dots to his emails, his phone calls, his conversations with his mother-in-law. They get all that information, and then they can file criminal charges on him.
That's right, and they don't just have to stumble upon the information. That's what the backdoor search is. The backdoor search is the FBI says, I have a criminal investigation on Joe Blow. And look, I have this huge database. There's a bunch of Section 702 data in it, but I'm going to query that data to see what I know about Joe Blow.
That's right. So they come across the information through a FISA warrant, they get the information on the American, and then they file criminal charges, and all of that is done without a search warrant under the Fourth Amendment to the Constitution of the United States against that American citizen, correct?
That's correct.
And I think that is illegal and a violation of the Constitution and an abuse of power by our government on Americans, for whatever my opinion is worth.
Mr. Chairman,
I yield back.
Mr. Jordan.
if I could, Mr. Chairman, so just the example that Judge Poe just went through, just to be clear, all the answers you gave and you get to that same individual, that individual could be prosecuted for something, you believe, something that's not related to national security as well.
Well, I know that that individual can be prosecuted for something that's not related to national security. You had also asked whether I think that's actually happening. I think the FBI uses all the authorities it has.
Can I also ask, Mr. Chairman, how many times does the FBI, how many times do we know how many times the FBI goes into that database and actually uses information gathered either under the FISA example that the judge just described or under a 702 example that I described in my previous round of questions? Do you know how many times that happens? We'll let the FBI answer. How about that?
The Privacy and Civil Liberties Oversight Board has commented on that, and they said that it's extremely rare that a query in a non-national security investigation returns information about a U.S. person from 702. But we don't know what the exact number is. Actually, the FBI has been ordered by the Foreign Intelligence Surveillance Court to count that number. So one pragmatic, relatively simple thing the committee could do is require that number to be published. Obviously not the details of the individual cases, but that top line number could add some transparency. And if the number turns out to be really low, that might relieve some people's concerns about this practice.
Wait, do you know that number, or you're currently trying to ascertain that number?
No, I don't, but the FBI does, because it has to report every case where a query in a non-national security investigation comes back with 702.
Okay, then you misunderstood. The FBI knows that number right now.
They're counting every case, so they know the number, and they're reporting it to the
But you're not allowed to give it to us today.
No, I'm a private citizen at a think tank, so
I thought you were with the FBI,
Sorry.
excuse me. I hadn't looked at the witness list that close. I thought you had some affiliation
Maybe I
with
look
the
like
FBI.
it.
You look like it.
Could I add one quick thing to that, which is I think it's also important, even though the court did not ask for this, for the FBI to report the number of
Okay, well, I have to ask you to
Oh, I
just
apologize.
cease for a moment. And the chairman of the full committee, Chairman Goodlatte, has to leave after he asks this question, so then perhaps we can get back. So Chair recognizes Chairman Goodlatte.
Well, thank you, Mr. Chairman, and I have no problem with going back to Mr. Jordan's questions if he'd like to pursue them further. And I do agree that we do need to address that issue with regard to what Fourth Amendment protections are given to U.S. citizens whose data goes through this process where it's taken by the NSA. A portion of that, a small portion, goes to the FBI, and the FBI saves it over a long period of time. I have questions both about the long-term retention of it and about what kind of threshold the government has to meet before they can use that information in a criminal case. So I think that's a legitimate issue that we need to consider as we reauthorize this program. I also think it's very important that we reauthorize the program, however, and I want to turn back to Ms. Doss, so maybe you can get us focused on the positive value of this, because it doesn't appear well understood that the NSA is a Department of Defense entity that supports the warfighter. And as former counsel of the NSA, I'm sure you are more familiar than the rest of us that NSA intelligence supports our military. So is 702 collection used to assist our men and women in uniform?
In my experience, yes, absolutely it is. And former director of the NSA, Michael Hayden, when he was still there, talked often about the ways in which in a post-9/11 world, tactical intelligence and national intelligence were really converging. Once upon a time, tactical intelligence to support warfighters on the battlefield was very much about troop movements. It still, of course, includes that. But in an era of asymmetric terrorist activity and asymmetric warfare, as many of our troops overseas are engaged in, the same information about terrorist plans and intentions that can protect the national borders and the broader national security absolutely has proven critical to protecting the warfighter as well.
Thank you. And Mr. Klein, I appreciate your comments a moment ago. I'd like to follow up on the discussion about the Privacy and Civil Liberties Oversight Board, popularly known as PCLOB. And I'd like to know whether you believe that the PCLOB still serves a valuable independent body for reviewing U.S. government surveillance programs.
I do. I think it does. Unfortunately, with only 2 members, and soon to have 1 member because one of the remaining members has been nominated for a high-ranking position in the Department of Justice, they do not have a quorum, which means they can't take official action. So unfortunately, the board is effectively paralyzed.
How many members of the board are there?
There are 5.
And how long has it been that there have been fewer than 3?
It's relatively recent. The chairman resigned last summer, which created its own problems. Only the chairman can hire staff under the statute.
So is this an indication of a lack of interest or support in it by first the Obama administration, now the Trump administration, or is it just circumstance that makes it ineffective right now?
I don't think it's specific to any administration. This is a long-standing problem going back to when the board was created. This is back well before 2010, and the board scuffled around for years, struggling to find enough members and staff to do its work. I want to emphasize that this isn't just a privacy and civil liberties issue, although it is that. It's also an important issue for our national security. This is an important part of our case domestically, but also to the international community, that we have rigorous and multi-layered oversight. And evidence of that is the fact that the General Counsel of the Office of the Director of National Intelligence in his letter explaining all of the rigorous oversight we have to our allies in Europe, cited the board as one element of that oversight. So I think even if you support this program, as I do, if you think it's important for national security, if you want it to be perceived as credible, we need to keep this board going.
Should the reauthorization of the FISA Amendments Act look to strengthen the P Club?
Yes, I think it should. I actually have the 3 specific proposals that the committee can consider. The most forward-leaning one is to require, as part of the FISA Court's annual review, to certify that the president has made nominations to fill any vacancies. Now, I think it should be limited to nominations. We don't want this program getting caught up in nomination politics, but that would give presidents an adequate incentive to staff something that, after all, doesn't report to the president. You can understand why it's not the #1 priority.
Are these Senate confirmed?
These are Senate-confirmed positions. 4 of them are part-time, but they're all Senate-confirmed. 2 other things that Congress could do. The board is subject to what's called the Government in the Sunshine Act. This applies broadly across the government to multi-member agencies, but it's a very bad fit for this board, which, after all, does not exercise regulatory power. We're not talking about smoke-filled rooms and deal-making here. This is just oversight, and 4 of them are part-time, so they need to collaborate informally. So requiring them to go through a very formal process just to hold a meeting really hampers them, unfortunately.
All right, well, look at that. That's a good suggestion. You have a third one as well?
Yes, I did. The chairman is the only person who can hire staff. So if the chairman resigns or is otherwise incapacitated, the board is paralyzed from hiring staff. Now, that's not an immediate problem right now. As I understand it, they're pretty well staffed up. But the Senate Intelligence Committee has proposed this, and I think it's a good idea. If the chair is vacant, allow the other members to unanimously exercise the powers of the chairman.
Thank you. Professor Kosseff, can privacy and national security coexist?
Absolutely, and I think 702 is a good example of it in terms of the various levels of oversight from all 3 branches of the government, the development of minimization and targeting procedures both by the executive branch and being approved by the FISA court. I think that shows a real concern for both protecting national security while making sure that privacy still is at the forefront. Obviously, all of the procedures can be improved, and on the flip side, there's never going to be perfect security or perfect privacy, and there's always going to be some policy decisions to be made. But I do think 702 in many ways is a model of considering both the very difficult considerations of security in an era when our telecommunications infrastructure is very different from the 1978 era when we initially had FISA, while at the same time protecting privacy. So the answer is yes, absolutely.
Some have argued that Section 702 must respect human rights, essentially extending American constitutional rights to foreign nationals. Do you have an opinion on extending constitutional rights to foreigners?
I think that's a tough decision or a tough issue that's come up with the ICCPR issue as well as PPD 28. And I think in some ways there are a number of statutory provisions within 702 that do apply both to U.S. persons and non-U.S. persons, including the various disclosure limits, the purpose limits, penalties for misuse. So I'd be concerned about extending, just as a practical matter of government surveillance and intelligence operations, and I think Ms. Dawson.
It would completely change the meaning of intelligence gathering, wouldn't it? And
yeah.
It would put the U.S. at a severe disadvantage, since I'm not aware of other major countries that gather intelligence respecting even the rights of their own citizens, much less foreign nationals.
I think it's a tough balance, especially, frankly, post-Schrems. I think there's a lot of concern about if the United States is not seen as adequately respecting privacy of non-U.S. persons, then there could be implications for the Privacy Shield, for example. But I don't have personal experience in intelligence operations, but I think it would probably create a number of very difficult logistical issues if we were to do that.
Very good, thank you. Thank you, Mr. Chairman. And, Mr. Chairman, if you wouldn't mind, after you've asked the additional questions, you wish to just adjourn the hearing.
Yep, I'd be happy to. Thank you. I want to thank the chairman for his questions and work. The chairman is asked the question, can privacy and security coexist? And I have the utmost respect for the chairman, but it seems to me that's the question for this committee is not that question. The question for this committee, the question for all of us is, can 702, is 702 consistent with the Constitution? I mean, that's the fundamental question. And Mr. Kosseff, do you think that's the appropriate question, and do you think it's actually happening?
I think it is the appropriate question, and I think based on what we have in the public record of how 702 operates, I think that it currently is consistent with the Fourth Amendment, but I give two important caveats. First, it's not a static answer. The answer could always change in the future based on any additional discovery of operational problems with 702 or how it's being used. And I think one key to that is figuring out exactly how you analyze the Fourth Amendment issues.
Yeah.
As I testified
You think,
earlier.
I guess, you think it's constitutional, but it sounds like you think it's pretty darn important to be skeptical. And be concerned.
Absolutely, absolutely.
I would argue that too. I mean, think about what we've witnessed in the last several years. We saw the IRS target people for exercising their First Amendment free speech rights, go after people for political reasons. We saw, I mean, you could look at the Flynn situation that Congressman Labrador brought up. So in that context, holy cow, I would almost say we better be more than skeptical, we better be cynical about it. Keep going, I'm sorry.
I think there needs to be constant, rigorous oversight. I think that there has been, both from your committee, the other committees, as well as the FISA court, if you look at some of the changes that have been made to things like the MCT issue in response to the FISA court, I think there has been rigorous oversight, but I think it has to be constant, and we can't just rest on one assessment that it's operating fine. It has to be constantly evaluated.
Ms. Doss, do you think that's the appropriate question? Is 702 consistent with the Constitution?
Absolutely, and in my view, it is.
Okay.
Both as written and as applied.
I had a feeling you were going to say that, yeah. Ms. Goitein, what do you think? Goitein, excuse me.
I certainly think it's the most important question. In my view, it's not constitutional, but I don't dispute the authority of the judges who have said otherwise. I just think that, as I said, this is a case of the law failing to keep up with technology. That happens often.
Mm-hmm.
And it becomes your job to step in and fill the constitutional gap.
Mr. Klein?
Yes, I agree that that's the first question. I don't think it's necessarily the last question. Even if it is constitutional, which I personally believe it is, and two courts have said so, you can ask whether it's wise or whether there's more information that we'd like to collect.
Mm-hmm.
So on the subject of incidental collection, which you talked about before, how much of Americans' data is getting caught up in this, the Privacy and Civil Liberties Oversight Board actually recommended 5 categories of data, including several of the things that Ms. Goitein was talking about, that the intelligence community is supposed to collect and report to Congress and to publish to the extent consistent with national security. That's called Recommendation 9. That's a good place to start. So there are things we can do to inform.
Let me ask about that, the dialogue you had with the chairman on this Civil Liberties Protection Board, or whatever the official title is. I asked you questions my last round about how many times the FBI queries a database and they get information that was derived from a 702. Does this oversight board know that number?
Nobody knows the exact number of queries. The reason is that the FBI does not normally code its queries for nationality, because nationality is not relevant to most investigations. I think it would be good to have an estimate of the number of queries. It's a fairly routine practice according to the board, so the estimate would be high.
So on the same question I started off with about a half an hour ago, I asked a question that we sent to Mr. Clapper about the number of communication of transactions involving United States persons subject to 702 surveillance on an annual basis. And we got the response back and said they couldn't figure that out. Does this board know that number?
They don't.
Yeah.
No, nobody knows that number. To do that, they would have to either go through every communication, which is simply infeasible, or some representative.
Sir, I mean, I got to believe that the NSA knows that number, but or they can get an estimate. Does the board know the estimate?
No, there is no estimate. I mean, the reason why an estimate might be difficult is because emails typically don't disclose on their face the nationality of the people communicating. In some cases, you might have the information telling you the location from where the email was sent. In other cases, you might not. Even still, that's not a perfect proxy. And the question is to find that out, to find out if the person is a U.S. citizen, what else would you have to do? Would you have to use other types of surveillance to get additional information about who that email address belongs to? That could create greater privacy harms. So while I agree with the motivations behind the letter, and I agree that the estimate would be worth having and a good thing to have, I do sympathize with the intelligence community because there are real practical obstacles that they're facing in creating such an estimate. That's why I think we should look at the recommendation 9 from the Privacy Board. There are 5 types of information that are a decent starting point for finding out about incidental collection. Let's get those counts. Let's get them public to the extent possible.
Tell me those 5.
Let's see, I have them here.
Or have you given us something in writing on that already? Okay, that's
Yeah,
fine.
I mean,
That's fine.
I can read them, but it'd probably be better to give them to you in writing.
That's fine. That's fine. All right, Ms. Goitein.
Quickly, the NSA has determined that the IP address is an accurate enough indicator of a person's status, being a U.S. person being domestically located, being located overseas, to use it to filter out the wholly domestic communications that the NSA is prohibited from acquiring. If it's accurate enough to enable the NSA to comply with that constitutional obligation, then it's certainly accurate enough for the estimate
Certainly accurate enough to give us a count.
that we're looking for. And just one other quick point about oversight and the importance of oversight, which I do not dispute. I think oversight is incredibly important, but it's not an end in itself, and it's never a substitute for adequate substantive limits in the law. If the law and the rules allow the FBI to read Americans' emails without obtaining a warrant, then the FBI could be scrupulously adhering to those rules, and we still have a problem.
Yep, well said. I want to thank you all for being here today, and the committee is adjourned.